Welcome to Notable Approvals. I'm attorney Amanda Shaffer. Before I get to our case for today, I want to quickly remind everybody that our next live Q&A discussion, which will be on naturalization, will be next Thursday, November 12th at 9 p.m. Eastern Time. I will post something later on in the week with more information about that, so keep your eye open. Follow us, like us, so you don't miss it at all. One more thing, if you are watching this and you're eligible to vote, I highly recommend that you do so if you have not already. And if you're not eligible to vote and you're watching this, you can certainly encourage all your family and friends who are eligible to go out and vote by tomorrow. So today's case is an interesting one because there's a lot of different parts. It is about a client who is a native and citizen of Germany. When he first entered the U.S. on an E2 visa, and he came to us after his previous attorney, who doesn't really do immigration law regularly, had filed his renewal, but made one major mistake that we see very often with attorneys who don't handle immigration regularly. And that was to make this as simple as possible, because this is one of those complicated parts of immigration law. When you apply for a B2 or an E2 or an H-1B, you're applying for an actual visa. A visa is an entry document. It's what you show at the border to get into the country. If you are already in the US and you need to extend your status or change your status, you don't have to get a visa unless you're going to be leaving the country at any point. Because you can only, even if you have multiple entries on your visa, you can only re-enter as long as the visa is valid. So with an E2, you're given 2 years, you enter, they stamp it, say how long you can stay. And then if you want to extend it while you're in the US, you can. And you don't have to do anything different. You file the I-129, you extend it. But if you're going to need to leave the US at all and you wish to re-enter at any time in the future, you're going to need a new visa. So generally, the way you do it is you file it with consular processing, where you're telling immigration, once it's approved, send my application abroad so that I can leave. When I need to leave the US, I can go to the consulate or embassy abroad and get a new visa and come back. So when he filed to renew his E2, the wrong box was checked. The file didn't go anywhere. So what we had to do is he had to leave for like his brother's wedding or something. We filed something called an I-824, which is an application on approved petition. Basically, we're asking USCIS to take here's his approval notice, here's a copy of his application, send it abroad so that when he leaves the US, he can then go to the embassy and get his visa. The only issue with those I-824s is sometimes they take a really long time. And in this case, he had to leave and the country before it was approved, which meant that he was either going to have to wait outside the country until the embassy got the application and gave him a new non-immigrant visa interview, or he could, because he's lucky to be from a country where he has a part of the visa waiver program, he could take a chance of trying to re-enter under the VWP. The problem with entering on the VWP is that USCIS is going to, or the Customs and Border Patrol are going to see when you land and try to enter the US that you have this E2 visa that was renewed, and you just because you have the E2 visa, your status that you have is how you enter the country, unless you then subsequently change it. His was changed before, so entering on a VWP, you can't pick up that E2 status without going back out. So like I said, it's a little confusing, but essentially we told him, look, if you want to try to go back, because he had a doctor's appointment, bring a doctor's note, explain to them that, you're going to leave again when the E2 is approved to go get the not the E2 approved, the I-824 is approved, so you can go to get the visa and come back. You're not going to work on your business until then. You're just here to, go to the doctor. You couldn't wait. So he did get in without a problem. And of course, the I-824 is approved like a couple of weeks later, but he had been dating a U.S. citizen for a long time. So we asked about getting a green card. Now, with the VWP, you can, as long as you approve the entry, you can file to adjust your status if you're eligible, and in marriage to a U.S. citizen makes you an immediate relative, so it makes you eligible. But there was another concern that came up because we told them don't get married too quickly. They might doubt that when you entered the U.S., with the VWP, what your real intent was. Because now, it was a little different rule back then, but now I think it's within 90 days. If you get married within 90 days to a U.S. citizen or do other things like file an immigrant visa application, then immigration will assume that you lied at the border and you have to prove them different. This happened right before that rule took effect, but they still can question your intent because they got married a few weeks later. And so we said, look, they had been dating for a while. They knew eventually they'd get married. They were planning to leave the U.S. to go get the visa, but plans changed and they decided, let's just get married now. They went to Vegas and got married. So we told them, okay, we just have to make sure it's very clear what your intent was. And my client, he was a little nervous for the interview, understandably, because he knew that they might question his non-immigrant intent, and that would mean we would need a waiver of inadmissibility for fraud, which you don't want to have to deal with if you don't have to. Luckily, in his case, he didn't. He brought all the documentation I told him to. He explained it the way he explained it to me. He was just honest about the situation. They believed him because they are trained. USCIS is trained to see if you're lying or not. And he did get his green card approved. He was very, very happy client. And I thought about this client because we are now doing their I-751 or their petition to remove conditions on residency so we can get his 10-year green card. So it's very exciting to finally take that step and not have to worry anymore. And we'll be getting that in soon. And then his wait will begin for that. But we have no doubt, we know they're a lovely couple. We have no doubt that will be approved as well. So if you need help with your immigration filings, our contact information has been scrolling across the screen throughout. I'll be happy to help you. Tune in tomorrow. We'll have another notable approval to bring you. And then again next week, Thursday, November 12th at 9 p.m. Eastern Time. Attorney Aaron Shapiro and I will be co-hosting live Q&A discussion on naturalization. Follow us, like us on Facebook and YouTube and LinkedIn and Instagram and wherever else, Twitter, so you don't miss out. Thanks for watching and have a great day.